in the custody of Yoko as he is granted bail. Meanwhile, former Vice President Dr. Mahmoud Bawumia raises concerns about Wontumi's arrest and subsequent detention. Plus, we'll also turn attention to the health ministry because the ministry and leadership of Ghana Registered Nurses and Midwives Association spar over conditions of service, pointing accusing fingers at each other. As always, I'm grateful for your company, but even more grateful as you watch us here on TV3, listen to us on 392.7 FM. We also stream on facebook.com, x.com, 3news.com, and on YouTube. Remember, you can be a part of the program with your questions, comments, and thoughts using the hashtag Ghana Tonight. Let's take a moment to bring you the night's biggest stories in summary.
Former Attorney General and lawyer for suspended Chief Justice Godfred Yeboah-Dami has expressed his disappointment at what he describes as the Supreme Court acceding to the perpetration against the highest judicial officer. The court unanimously dismissed the injunction application filed by Gertrude Tokunu seeking to bar the Committee of Inquiry probing petitions for her removal.
I'm quite surprised that the Supreme Court will more or less acceding to the perpetration of such violations against the highest judicial officer. The issues are far reaching and actually hinge on matters which affect the independence of Ghana's judiciary, the security of tenure of judges and all.
The Majority Leader of Parliament, Mahama Ayariga, has asked the suspended Chief Justice Gertrude Tokunu to accept the procedure to remove her from office. He posists that the Constitution has stated it clearly on the removal of a Chief Justice, which, according to him, is being followed appropriately by the President.
So far, I have not heard anybody specifically say that this part of the process is not provided for in the Constitution. Somebody says, I want the hearing to be held in public. I want a transparent process. Did the Constitution say a transparent process? Did the Constitution say a process in camera?
President John Dramani Mahama has removed from the NHIA board amid backlash over her disputed medical credentials. Though the official letter gave no reason, the decision follows criticism of Dali's claim to be a licensed medical doctor. She has been replaced by Professor Dr. Ernest York, a respected physician and former GMA Greater Accra Regional Chair, whose appointment has been positively received. President John Mahama has outlined the comprehensive vision for Ghana's anticipated 24-hour economy policy, describing it as both a destination and a program crucial for the national reset. The announcement came during a pivotal meeting in Accra concerning the rollout of the 24-hour Plus program and the accelerated export development framework.
We'll have to operate in multiple shifts across day and night, maximizing the return on infrastructure, on human resources and innovation. This idea captured the public imagination during the 2024 campaign and remains at the core of our drive towards full employment and inclusive economic growth.
Over 128,000 nurses and midwives across Ghana are to withdraw their services in the next 10 days. The Ghana Registered Nurses and Midwives Association says it is disappointed with the government's delay in implementing the assigned conditions of service. President of the association, Perpetual Ofori Ampofo, was addressing a news conference in Accra.
We know our call to duty and we are ready to do it, but we cannot sit aloof when our collective agreements, which will motivate us to work, which will take us in terms of transporting us to work, which will take us in terms of feeding us, which will take us supporting our families, it's not given. We cannot just sit back and allow it to happen. We are not the only public sector workers. We have seen other collective agreements being implemented within the last 5 months. We have seen them. So why is ours not being implemented?
It's still Ghana Tonight here on TV3 and 392.7 FM. I'm Keminni Amanor. We'll switch things around a little bit today. We'll take our break now, so we'll have uninterrupted discussions when we begin. So let's take that break now. We'll be right back. Don't go away.
If whiskey could talk, Johnny Walker Black Label would sing. With notes that only come with 12 years in a barrel. Sweet, smooth toffee, rich fruit, and a touch of smoke. Tastes as good as it sounds.
Drink responsibly. Not for sale to persons under 18 years of age. Not recommended for pregnant women. This advert is FDA approved.
Why are more and more professionals choosing flamingo paint?
As an interior decorator, I aim for that beautiful elegance look. Flamingo paint has great hiding ability to cover and transform old walls easily with just one coat.
Impressive. For me, as a professional painter, I love flamingo paint because it is small paints that paint huge area, meaning more profit for me. Great value for money.
As an architect, Flamingo Paint, with its well-researched and solid composition, guarantees durability for all my buildings.
Flamingo paint, superior hiding, superior coverage, superior durability. Flamingo paint, simply superior.
Michelle,
Different era, better result. Time has changed and time has brought Kel Choco toothpaste, healthy gums, anti-cavity, fresher breath, and it whitens teeth. Kel Choco toothpaste, Sankofa.
Yenchi, Kel Chocolate toothpaste.
Happy smile.
This advert is FDA approved.
Yes, next. Hey, Nadia Benson,
me didn't tum. Mr. Freddy Calico just call me cockroach. Now, Mr. Freddy once now. Hey, is that you? Improve car. Yeah. Captain Mosquito, double the action. Me did it, Sasso spray. Mr. Freddy Sasso quell. Yeah, go to my Sasso.
Tum preko.
All the taste we want in a beer. Rich, silky. Delicious Guinness smooth. Bold and vibrant as you.
Welcome back to Ghana Tonight. Let's get the show on the road now. Suspended Chief Justice Gertrude Torkornoo's attempt to stop impeachment processes on her hits a snag. We'll tell you more right now. Tonight, a former Attorney General and his predecessor face each other in court over, in court, they argued their positions on why or why not the impeachment processes against the suspended Chief Justice should be halted. Gertrude Torkornoo attempted to prevent the committee probing her removal from doing its work. At the end of the hearings, the Supreme Court blocked the attempt, paving the way for the process to continue. Now, Dennis Widam, my producer, was in court all throughout the hearings today. He brings us the very latest, a total look at the chronology of events that took place in court earlier today. Dennis, talk to us. We have seen interlocutory injunction application, one after the other, a total of 5 at this point. Today is the first one that the Chief Justice herself appeared in court in person for, because her name also appeared on that document. Talk to us about how events played out in court today.
Well, so today, actually, like you rightly indicated, is the 5th time we are seeing an interlocutory application before the Supreme Court, all geared towards stopping the processes that are ongoing, seeking the removal of the Chief Justice. This particular one is a bit different because in there, you have the Chief Justice herself now being a plaintiff applicant in this particular matter. However, the outcome is not any different from the others that have come before, except to say in this particular one, the ruling of the court has been a unanimous decision. In the 2 that came before this one, the ruling of the court was a 4-1 majority decision. They dismissed that. The first one that came before the court was a 3-2, and today's, like I mentioned earlier, was a unanimous decision by the court. But in order to put things into perspective, Keminni, let's begin to look at what actually transpired in court today. Quite a number of things to observe. That for the first time for many, they saw the Chief Justice herself come into the courtroom from a different place altogether. Because on a normal day, she would have come through the chambers to the bench. So like walking from her backside, the backside of where they sit in there. But today, she used the part where everybody uses. Like you and I go into the courts, we use that into the courts.
I can imagine how strangely that must have felt for her.
Yes, and it was quite, strange, like you see. But those who were there understand the circumstances. And also, even with the sitting arrangements, ideally, she would be on the bench. So there's the bench, there's the bar, and there's a place where parties sit behind the bar. So she was behind the bar to say that, okay, I have a case, I am here, just like you and I would. So that was quite a special observation to be made for today's proceedings. But beyond that, even before they could get into the substantive matter, because the business for today actually was for the hearing of the injunction application that the Chief Justice is seeking to stop the process. She raises quite a number of issues, praying that the process as it is going against her should be halted because she complained about quite a number of violations. But the preliminary matters that had to be determined before they got into that substantive issue was one, an issue that was raised by the Attorney General, who was represented by the Deputy Attorney General, the learned Dr. Justice Remsai. He was praying the court to exclude from the suit the 5 members of the committee who are probing the petitions that are seeking the Chief Justice removal. And just to put that into context, so this is how the respondents look like. So you have the Attorney General as the first respondent, and then following that are the 5 members of the committee sued in that order. So the Attorney General's argument was that take out these 5 people, let it be just the Chief Justice as the plaintiff applicant and the Attorney General would be the defendant respondent.
What was the reason for that?
So his reason was simple. That on the face of the writ, you would find that the Chief Justice makes the point that persons to be affected, in one of the paragraphs that have been stated in there, to be affected in the suit would be the Attorney General. According to the Attorney General or the Deputy Attorney General's argument, it didn't say more. So in his view, if the only person who is going to be affected by the suit is going to be the Attorney General, then why do we have this? He also makes the case that these people, their specific addresses had not been provided for on the face of the writ. However, that was opposed strongly by the former Attorney General, Godfrey Adami, who is the lawyer for the plaintiff in this particular matter. That's the Chief Justice. His argument was simple, that when you're looking at whether somebody is a proper party to a suit or not, it's not just about naming the person or mentioning the person, but as long as claims or reliefs are sought against those persons, they are proper parties. And he did indicate that when you look at the writ and the reliefs that they seek, as many as 6 of them are against members of the committee. And to that extent, they are proper parties. They should be a part of the suit. This found favor with the court, and the court overruled that objection that was raised by the Deputy Attorney General. Just when that was cleared, you recall yesterday on this show, we did indicate that the Attorney General had filed a notice of legal objection to the effect that he wanted to exclude from the processes a supplementary affidavit that was filed by the Chief Justice. In there were some depositions that were made or statements that were made which have something to do with the in-camera proceedings that are ongoing. It was the Attorney General's view that those depositions or those statements are supposed to be protected by the Constitution under Article 1468, which requires that such proceedings be confidential. And to that extent, it was not proper for them to be brought before the courts. I mean, the former Attorney General opposed to that. His argument or counter-argument was that, in his view, what amounts to proceedings is different from what they are complaining about. And that, in his view, the proceedings will include the petitions and the actual hearings. But what they are complaining about, including the searches and all, in his view, are not proceedings. He also says that if the argument of the Attorney General is to be upheld, what it means is that even if there is an overstep of some of the actions of the committee members, it means that you will not have the right to even challenge that decision, because the question of confidentiality will come up. So he thinks that the supplementary affidavit was necessary and it ought to be part of the processes. The court had to take a decision on that. They came, and this particular legal objection by the Attorney General was upheld. That is to say, the affidavit, the supplementary affidavit, was struck out of the process.
And will no longer be part of the case. But,
not at all,
you know,
yes.
I'm just wondering, right? Because in that application that the Chief Justice had made or so, it wasn't just about the in-camera issue. She had also raised issues about mental torture and how, you know, the location for the exercise itself was changed, and it was meant to somewhat intimidate her. Now, by this ruling, how do we translate that in English as per what she wrote in those applications?
So like I tried to explain, there was an attempt to explain what amounted to proceedings. Now, when you even look at the supplementary affidavit itself, it did state that these were matters that arose as a result of her appearance before the committee. So that in itself, I mean, that was the view of the court. That in itself created a sense that it was part of the hearing of the committee that those matters came up. Indeed, the former Attorney General made a point that when you look at the affidavit, he says that from paragraphs 1 to 6 were not matters within the proceedings. But when they read it to him and asked if these matters did not only come after she went for that hearing, I mean, it was difficult to justify. So on that score, they deemed those matters to be matters that arose from the proceedings, which is supposed to be in camera, and that the sanctity of the process needs to be protected under Article 1468, and to that extent, it should not be part of the record.
Which means that out of the Supreme Court ruling that we have today, all those things, the allegations, the concerns that the suspended Chief Justice held will not show up anywhere
Okay,
in the case as it's being heard?
Okay, so mind you, the supplementary affidavit in support was for the application for interlocutory injunction.
Only?
Yes. So what it meant is that if the court is considering all the facts before it, it will not consider any fact that was included in that supplementary affidavit. In fact, the court had reason to tell the lawyer for the Chief Justice, that's the former Attorney General, that he could have actually prosecuted his case without that supplementary affidavit. And that their view is that it is matters within the proceedings before the committee.
I mean, speaking of the former Attorney General, Godfred Dame,
yes,
we know that he also expressed misgivings about how the case turned out today in the Supreme Court. He thought it was violations of the rights of, the occupant of the highest office in the judiciary. I want us to take a listen to Godfred Dame at this point, because we'll come back to Dennis. Dennis will share with us what the next process is. Because remember that we'll bring you that video clip in a bit. But Dennis, remember also that these are only interlocutory applications.
In fact, preliminary, even before the interlocutory injunction itself could be heard. Even in fact, there was a third one, and that was raised by the former Attorney General, the learned Godfred Dame. His argument was that, his objection was the AG's representation of the 5 committee members. His argument simply was that as an Attorney General, you are basically the legal advisor to the government, to represent government officials and all that. He was wondering why it was the Attorney General who was representing the justices, Daniel Yaodemolevu and the Major Flora Balugu, and then Professor James Sefa. He thought, or he argued, that these persons were sued in their individual capacities. So the Attorney General did not have a role to play in representing them in Parliament. So they ought to have come with their own lawyers. However, there was a conversation with the bench where the bench asked him that, for instance, the justices were doing their job as justice of the Supreme Court. The president nominated them to be on a committee. It was not by their own doing that they got into the committee, for which they have now been made parties to this suit. So to argue that they have been sued individually, for which they needed to have their own lawyers, was an argument they could not subscribe to. In fact, they even indicated that if, for instance, so in this particular matter, they did not agree with the former Attorney General that these people needed to have their own individual. What they said was that they were performing a public function, for which they also deserved the service of the Attorney General. In fact, he did not push it further when the bench urged on him to rest his objection.
His argument on that.
So they let that.
I'm going to come back to you, because I want to learn whether or not, the argument about Justice Pwamang having, sat on cases involving, 2 of the petitioners also. I want you to dig down on that and how it played or did not play out in court today. But let's take a listen to former Attorney General Godfred Dame. Like I said before, he had misgivings about the outcome of the Supreme Court hearings today. Take a listen.
Was not pleased with the outcome.
I'm quite surprised that the Supreme Court will more or less acceding to the perpetration of such violations against the highest judicial officer. The issues are far reaching and they actually hinge on matters which affect the independence of Ghana's judiciary, the security of tenure of judges and all. But if the Supreme Court, for whatever reasons, does not seem to take that view, well, so be it. I think that in future, the whole nation will get lower.
He maintained that the suspended Chief Justice will continue to assert her rights.
She knows what is due process. She knows what is constitutional rights. And I think that's what she's asking for. And how can it be correct that a judge who sat on 2 matters, of which she also sat, called a witness, be called as witness in a petition against her, and that same judge be made the chairman of the committee that is supposed to inquire into the petitions against the Chief Justice.
Godfred Dame is former Attorney General of the Republic of Ghana. Dennis Wedam is still here with me. Dennis, that's concluding remark he made is just about what I was talking about before we took the video clip, right? Did that come up in court today?
Yes, it did. So that was one of the main things that was argued in respect of the main injunction application. And the former Attorney General, I still refer to him as Attorney General for some reason. I mean, it will take some time to go, but yes, the former Attorney General, he made the argument that the two justices, Justice Gabriel Palmang and Justice Samuel Seidu, should not be part of the committee. His reason for Justice Gabriel Palmang is the fact that he had given judgments which went in favor of one of the petitioners, Daniel Ofori, in this particular matter. The bench asked him if it was just the issue of giving judgments that went in favor, and that if they, as justices, had given judgments that went in favor of some other individuals, does that mean that when they meet them again in other fora, they cannot? So he explained that it's not just about giving the judgments, but that judgment has now become a subject of the petition itself. And that was the basis for his objection. But yes, they still went on to prove further that if, for instance, they, as justices, so at this point, Justice Yoni Kolendi was the one doing the questioning, together with the president, Justice Paul Bafoboni, that if they, as justices, for instance, they give judgments in favor of somebody, and then again, they are promoted. He even used the example of promotion of justices from the lower courts to the higher courts, where they go to meet decisions that they had made at the lower courts, for instance, and then they are supposed to sit on it. Should that be basis for them to recuse themselves or not be a part of it? Then, in fact, they even did indicate that that particular judgment they're talking about, that's the claim, or they say that Justice Palmang gave judgment which went in favor of Daniel Ofori. Justice Yoni Kolendi and then the president, Paul Bafoboni, were part of it. So they asked the former Attorney General that, so they do not qualify to be part of the committee. He said, no, he said, under the circumstances, no.
I mean, so he was, they got him to admit.
Not to admit, but he still stood his grounds. He was forceful about his argument that for the fact that that judgment has now become the subject of the petition, if they too were also part of it, then the argument still applies to them too. Yes. So he was forceful in argument. For Justice Samuel Seidu, the argument is one that has been repeated. And I say repeated because it has come up before. The argument simply is that when Vincent Esefwa first filed his injunction application, the first panel that was constituted, he was part of it. However, the court could not sit. It was adjourned twice. By the first adjournment, he was appointed to be part of the committee. The Attorney General's argument is that this is a man who was part of a panel that was supposed to look at a matter that affects the issues we are talking about. So he should not be a part of it.
And that's Godfred Dame's argument, right?
However, I mean, because the full ruling of the court is not out yet, you are unable to tell the reasoning behind that. But what is obvious is that at the end of it, I mean, together with the opposed argument from the Attorney General or Deputy Attorney General who was in court today, the court came to the conclusion that, no, we are not persuaded by your application. It is without any merit. On that basis, we are dismissing it. This time around, it was a unanimous decision, all 5 justices. And if you don't mind, yes, this is the panel for today.
I see. And you know, I can't wait to read the reasons for the decisions that have been taken today. Again, remember that yesterday when we spoke about this, I had indicated that for the 3-2 decision in the Vincent's case, one of the elements or criteria that they had pegged, you know, the decision whether or not to agree to an injunction of the process was the inability of the applicant to show that whatever was going on will have a direct impact on him. And I'd like to see what the argument will be in this case, whether or not it applies at all. Because, I mean, the ruling was very emphatic that based on previous rulings or precedents, you needed to, you know, in order for that injunction to be given, it needed to be able to meet certain requirements. And one of those requirements was that.
Precisely so. Yes. And just to add that was the beginning point of the Attorney General, Deputy Attorney General, who was in court making his arguments in opposing this application, to say that the court itself has, even before today, given decisions dismissing such interlocutory applications. He goes back to cite parts of their own judgment in the Vincent case to make the case that, look, I mean, we have been here before. A lot of these matters have been argued before. The court did not find them persuasive. Why are we doing this again, so to speak?
And it's usually a persuasive argument
yes, before
when you
adding on
them
to the specifics that was on it. And eventually, I think he had his day on that. And, I mean, this is the panel. The only difference with this panel is that the last person here, His Lordship Justice Seji Frimpong, is the new person in here. Because in the previous two cases, in his place was Justice Asaradapo. He was here. But these four still maintain their places. And anytime you see them like this, it means the one in the middle is the president.
Is the president.
The oldest to his right is the next oldest. To his left is the next oldest. It goes in that order.
I see.
That's just a thing for you.
Interesting. I didn't know that.
Yes.
I didn't know that. Thank you so much for that, the clarity you have brought to the matter. But where do we go from here? Because you remember that at the beginning of the program, I indicated that, it's taking us one step closer to the end. But are we really that close to the end? What happens next? Because there's another case in court, right?
The only cases that are left in court will be the substantive cases because, all these are interlocutory injunctions which are usually mounted on substantive cases. I mean, the court was careful in not going into the substantive matters. So each time counsel were arguing and they were veering into the substantive matters, the court was minded to caution them that no, hold your horses, just stay focused on the interlocutory injunction, make your arguments to that respect. So the only cases that are pending that we know about, unless, of course, there's been new cases that have been filed today or that will be filed tomorrow, are the substantive matters.
The one to do with the prima facie evidence?
Yes.
Okay.
And the declarations that are being sought, and whether or not she can waive her right, and all those matters. Whether or not the petitions ought to be given first to the Chief Justice before the response, as was in the Vincent case. All those are still substantive matters that need to be decided. But for the interlocutory injunctions, we are done with them. The committee is doing its work, and that's about it.
Dennis, as always, a pleasure having discussions with you on matters of the law. Thank you so much, Counsel.
Always a pleasure being here, Keminni.
Now, let's hear from the director of the Ghana School of Law, Kweku Ansah-Sarah, because he has some very interesting views on how, this fast-moving story has developed so far.
I don't think she's fighting for the entire judiciary. I would rather, say that she's fighting her way out, of the seat of the CJ. This is a matter that if we try to stretch every point, every relationship, every attitude, every body language, we'll press all these things to a point of absurdity. Let me give you one instance. It is being alleged that that is Pama or Tidu, this or that. And then I keep asking myself, if one of the petitioners or the petitioners will say that Justice Rita Mensah-Bonsu should refuse herself because she attended Wesley Girls, and the Chief Justice also attended Wesley Girls. I mean, we are just trivializing, a rather, important matter of national and public interest. So, overstretching this thing won't help anybody. The fact is that we have a constitution, that is, the working blueprint for the entire nation. And the constitution mandates the president to take certain constitutional steps. The president has taken those steps. The president hasn't violated, any stage of the process. Now we are being asked that, told that the president must try to reverse, the position. And there is nowhere in the constitution that even suggests that the president can reverse the process. The president may decide to lift, the suspension, but the president cannot, reverse the process. It is irreversible. So, if I were the legal team, of the CJ, I would rather suggest to the CJ that you take a back seat. Let us do all the dirty work for you. At the end of the day, being, subject to the Constitution itself, you should accept the outcome. Right. Howsoever it may turn out, do accept it, and then we'll bring this matter to an end. But dicing her out for the kill, is ill-timed.
Okweku Ansari, who is the former director of the Ghana School of Law, was speaking on 3FM 92.7 earlier today. We also know tonight that this quickly developing story once again came up in Parliament, where Majority Leader Mahama Yariga is now asking the suspended Chief Justice to just accept the procedure to remove her from office. And again, some interesting points being made.
Anybody specifically say that this part of the process is not provided for in the Constitution? Somebody says, I want the hearing to be held in public. I want a transparent process. Did the Constitution say a transparent process? Did the Constitution say a process in camera? If the Constitution said a process in camera, when you are being vetted in this Parliament and you are being appointed as the Chief Justice, why didn't you say that I am accepting the job subject to me not accepting the procedure for removing me? If you had told us at that time, would we have appointed you as Chief Justice? It comes as a package. You cannot accept to enjoy the perks of the office of Chief Justice, and then the procedure by which you will be removed, you say that you not accept that one. Where were you when you were being appointed Chief Justice?
Now, remember, we also spoke about the Majority Leader yesterday when he made very bold pronouncements on the floor of Parliament regarding the desire of the current administration to make the removal processes smoother, backed by legislation. Today, he appears to give more clarity and substance to what he has said. Because again, remember, we had the conversation about a counterproductive position with the Majority Leader's comments yesterday. Today appears to give more clarity to what we heard yesterday from him on the floor of Parliament, and we can now turn attention to other matters. Because tonight, many questions are being asked about Chairman Wontumi's continuous detention. Only in the last few hours of the night, we heard that he has been granted bail. The question now will be whether or not he has met those conditions and he's been released. Let's get into that now. Now, Chairman Wontumi granted bail after spending the night in hospital while in Iyoko custody. Media reports attributed his lawyer, Andy Apia Kubi, indicates Wontumi's bail was to the tune of 50 million cedis pending investigations. Now, this is the second bail the NPP Ashanti Regional Chairman is receiving after the CID cautioned and released him on bail on Monday. It is unclear why he's being held, but the reports also suggest that Iyoko detained him and are actively investigating Wontumi for causing financial loss to the state. Now, the bill comes hours after interrogation at the Iyoko head office in Accra on Tuesday, which allegedly sent Wontumi to the hospital because he had taken ill. Now, I can also tell you that we're getting information on issues around this bill. And from our sources, I'm going to read directly what our sources have sent us only in the last few minutes regarding this. He has been granted bail. We shall file our documents to comply with bail conditions tomorrow. That is what we're getting from our sources. Now, the question will be whether or not, now stay with me, whether or not being granted bail means that he has left. But if he has left, did he meet the conditions before his release? Or is he still in custody pending his release? And if he is still in custody, then I'd also ask whether or not he's at the hospital or is being held in detention at Iyoko. Very important questions to ask, also because Iyoko is not sharing any information with the public. Now, the question is why Iyoko is not sharing any information, and perhaps when we bring on security analysts who has worked as a national security operative in this country for a long time before. He'll help us understand why Iyoko would have a public spectacle of this nature and still not speak to it. But we also know that earlier this afternoon, the former Vice President, Dr. Mahamudu Bawumia, weighed in on the arrest and detention of Chairman Wontumi. And I want to break down some of the things that he's spoken, first expressing his disappointment by how things have been handled. But in his own words, this is what he's been saying. Let's take a look at that. I am deeply concerned about the arrest and continued detention of the Ashanti Regional Chairman of the NPP, Bernard Enchibwe-Siako, also known as Wontumi, particularly as the charges remain vague and his whereabouts remain unknown. He goes on to say that in a democratic environment as ours, no individual above the law, equally no Ghanaian, regardless of political affiliation or status, should ever be denied their constitutional rights. Justice and due process are not optional. They are the foundation of our democracy. And then finally, he says, Ghana must always remain a nation governed by law, not by the arbitrary power. Our republic is strongest when our institutions are both firm and fair. So that's coming from Dr. Mahamudu Bawumia in the late hours of the afternoon. But we can have a conversation now with Richard Kumado. He is a security analyst with extensive knowledge of national security operations, having given his experience there. Richard, I raised a number of questions about, the information that is trickling in now about Wontumi's bail. Now, being granted bail, having not met the bail conditions, documents to be presented tomorrow, does not translate into release. At the same time, we do not hear from Iyoko, and it's very, it's a comfortable position to say that Iyoko should not talk to the public. But when an arrest and detention become a public discourse or a public spectacle, then we expect Iyoko to speak to us. Will I be wrong to expect that from Iyoko?
No, law enforcement agencies are aware that when it comes to issues of crime investigations and crime suspects or subjects of investigations have been picked up for questioning or for interviewing, they are mindful of the 48 hours rule, and where they will need the extension of the client being with them further, then they will have to go to court. And you remember Lawyer Kwebu was critical when it comes to crimes and when it comes to arrest and when it comes to detention. And Raymond actually is very much aware of that. In that regard, there could also be an arrangement with the lawyers. And I believe that is why the information coming out to your desk is not being straightforward. You are getting it piece by piece. What is important is that he has been with them. If they haven't finished answering him all the questions in relating to the particular crimes for which Iyoko picked him up, then they also have the opportunity to ask him further questions. But to the extent that he wasn't well, then that is a peculiar situation. And that is why it is going the way it's going. But what is important is that his right has been respected, and the state also have the opportunity to speak to him because he has come under some level of crime investigation interest for the state.
But I mean, if you were to hazard a guess on this situation, the fact that we know for sure that the bail conditions have not been met based on what our sources are telling us, we can presume that Chairman Wontumi is still in the custody of Iyoko. Is that the operational style?
Keminni, what you are trying this evening is not good at all. You should have been wearing blue shirt. Today you are wearing red, so your eye red for the stage there. Wait, they might not be holding with me more than 48 hours. And if they do, then they are mindful of the fact that they have to go to court and meet the limit within which they can operate. We should conjecture, and we should put up a proposition that will say that they are holding him more than 48 hours
but Richard,
against his will.
My position is not that. My position is not that Iyoko is holding Chairman Wontumi.
No, the point I'm making is that when the full facts are not made available to you, it's always important to be subjective and not definite. And with that regard, it's in line with standard procedure when it comes to investigation. So let's leave it at that.
So let me clarify the question, right? Now, we know for sure that he's been granted bail. So the question as to whether or not Yoko is holding him beyond reasonable hours is not at play here, because Yoko has granted him bail. What we are hearing is that those bail conditions have not been met yet, because the documents to support the bail conditions will be presented tomorrow. Now, my question to you is, based on your knowledge of national security operations, do you think that because the bail condition has not been met, it is most likely that Chairman Wontumi will still be in the custody of Yoko?
Whichever way it plays, I believe there's going to be a decision made by the investigators or the head of Yoko and the lawyers of Chairman Wontumi as to how to clear between tonight and tomorrow morning when they are determined to make the bail applications full. So let's leave at that. Once there's an official position from them, we can look at it. But what it is now is that he has been granted bail. The bail conditions have been met halfway. As to whereabouts of Chairman Wontumi, it will be in the interest of his lawyers to speak to the general public. But he's somebody under investigations, and the investigators are mindful of the fact that they have 48 hours to ask him most of the critical questions they wanted to ask him. And so that is the peculiar situation we find ourselves in.
You make a fair point. But, you know, I'm back on the issue of Yoko's communication with the public. Should Yoko, at this time, be speaking to the public one way or the other?
I am a brother of the investigation agency. So predominantly, you have spoken to me for the past decade. What I do is to grant public education, create awareness, and to offer alternative sources of reasoning, and to bring home the standard procedure. Yoko is an investigative agency, and they fall within the national security architecture, and they have particular interests or peculiar questions they want to ask Chairman Wontumi in relation to a crime that has become an of interest to him, whether he play a direct role, a peculiar role, or indirect role. To that regard, there are standard procedures to follow. If Yoko decides to issue an official statement, it will come into the general public. To this day, they have none. And so that is why you have Richard Kumado to add up to where they have left off. And once they make an official position, we can look at it. Other than that, I am speaking competently as somebody who has dealt with investigations and follow criminals and know how these things are done for 28 years. I have been in this space, not just in Ghana, across the globe. So take my words as competent as possible. And once Raymond and his boys at Yoko made a public statement, we'll look at it. Other than that, these are the premises at which
very well. I mean, let's juxtapose that to the investigations that are ongoing with the police CID. We do not know exactly what has happened or what the charges are in the case of Yoko. But when somebody appears to be under concurrent investigations, remember also that the CID granted him bail on Monday before his arrest. How do the security operatives collaborate then to ensure that, listen, they can both work and get to the point where they target to get to in terms of the investigations? How does it play out?
You remember not long ago, a case came up about one of our big aunties in this country involving some amount of dollars. And in that particular case, we made the argument strongly that when it comes to financial crime, you have financial FIC, the Financial Intelligence Center. They are interested in that case. Yoko has economic interest in that case. The Special Prosecution have an interest in it. The BNI or the NIB has an interest in it. The Financial Crime Unit of the Ghana Police Service have an interest in it. So you have become an investigative element for these 5 institutions. I have heard in the afternoon where people said that it was the CID that invited him. Then, as when he left there, Yoko picked him up. People have forgotten that FIC came out with a release that his accounts has been frozen, and it was his lawyer who said that, whether it was his company account or it was his personal account. Now, if you understand how FIC or the financial intelligence works, predominantly in the area of money laundering and financial crime, you have Yoko who does the investigations for them, and you have the BNI who does the investigations for them, and you have the police service, the CID blog. Exactly. So it might be that this particular charges or these particular questions that Chairman Wontumi is being asked might have something to do with some of his accounts being frozen or some other cases that they believe he has questions to answer, and they need him in person to answer those questions. So we always say that when there are multiple cases you are involved in, you may not know it all until you sit before the investigators. And that is why when notice is served, you should deem it necessary to deal with the investigators. Other than that, you could be delayed and your freedom could be curtailed. And I think that is what happened to our big brother, Wontumi, in this particular case.
Indeed. Richard, I appreciate your insights on the subject matter. Thank you so much for talking to us. Richard Kumado is a security analyst with extensive knowledge of national security operations. We'll take another break. When we come back, the Health Ministry is urging health workers to rescind the decision to strike. When we come back, I will tell you why the health workers say there's not a chance.
Malaria remedy is
Welcome back. Happy to know you're still here with us on Ghana Tonight, because the country could be headed into a health crisis if the over 128,000 nurses and midwives who plan to go on strike in the next 10 days indeed withdraw their services. Now, the health workers via their parent organization, the Ghana Registered Nurses and Midwives Association, say they are disappointed by government's delay in implementing the assigned conditions of service. And listen, if you started with us, you may have heard the president of the association speak to this matter. But we know that tonight, the health ministry has also released a statement indicating that the Nurses and Midwives Association is acting in bad faith because there have been 5 consecutive meetings. At those meetings, they had agreed to form a committee to continue the process because, mind you, the signed conditions of service began in the previous administration. It was agreed upon and all, and then they were kicked out of office. There's a new government, and the nurses are now afraid that they may want to review the situation, review the conditions of service, and they don't want it done. Because once it has been agreed upon and signed, they just need the health ministry and finance ministry to process it, and then that's it. So I'm going to bring in now Dr. David Tinkran-Chum, who is General Secretary of the GRNMA. Let's have a quick and brief conversation on the back of this. Doc, good evening to you, and thank you so much for your time. The health minister says you're acting in bad faith. How does this come to you?
All right. Thank you, and good evening to you and your listeners and your viewers. As a matter of fact, I'm also surprised by the conduct and the release from the ministry. And I've just had the opportunity of reading through the release, and there's a portion that they recounted. We've met 5 consecutive times. And you ask yourself, what was those 5 meetings trying to resolve? Clearly, it shows that there are not people who are committed in resolving the matter. Let me hasten to add that we've seen some semblance of commitment from the Minister for Health. But same cannot be said for the Minister for Finance. Why am I saying this? This is not a new document. This document was signed as far back as May 2024. A new government came to being. Of course, we had some few challenges, as we stated in our release, but we got it resolved by January. A new government came to being. We started working with the then chief director. He gave us the assurance that this is not a document that is yet to go through another route of renegotiation, which is the case anyway.
Indeed,
and that the document was actually at the Ministry of Finance before the elections was held.
Very well, Doc. We know the chronology of events at this point, but the ministry is asking that you rescind the decision to strike. Will you do that?
I'm saying that it's a legal document which is binding on the employer, and the employer, you see, if a government comes to office, you inherit both assets and liabilities. All right. So I don't think anybody has even suggested that they want to review the condition of service. That will not even happen. But I'm saying that it's a legal document that has been signed. All what they need to do is to implement it and pay the necessary arrears that has accrued from 1st of July that was supposed to be implemented in 2024. And that's what we are expecting. I mean, if anybody says that we want to sit down, I'm saying that.
Indeed. I mean, but this strike is supposed to encompass all of the health workers who fall under your association. But we know that a splinter group, which was also working on this with you, is now saying the agreement, there was no agreement for an industrial action at your last meeting. So why did the GRNMA do otherwise and declare a strike?
Well, respectfully, I'd like to decline comments on this particular issue.
I mean, is there a broken front when you're taking and negotiating such an important step?
Negotiated. I told you that we have already negotiated the document. I mean, it's not subject for renegotiation. We've gone past that stage.
No, of course, I understand that.
Is there anything else you want us to talk about, please?
Absolutely. There are a few more things I want us to talk about. The question now will be, is the group part of the GRNMA?
I think I'll leave it as it is. I think I'll leave it.
Did you meet with the said group, the finance and health ministries?
No point did we say that there was not going to be any industrial action.
We'll leave it here. Thank you so much, David, for your time. David Tenkran Chum, doctor, is General Secretary of the GRNMA. We've been discussing the health matters. There'll be more on that story in later broadcasts. Join us at 6 a.m. for the news at 6 on New Day here on TV3. But that'll be all tonight. I do appreciate your company. My name is Keminni Amanor. Have a good night.
Ghana Tonight is brought to you by
Flamingo Paint. Superior durability, superior hiding, superior coverage, simply superior.
Sasso